The International Anti-Terrorism Law. The introductions to International Anti-Terrorism Law, state terrorisms and state-sponsored terrorisms, Universal Terrorism Conventions, challenges in defining what is terrorism, the main provisions of the conventions regarding universal terrorism, quasi-universal jurisdictions, refugees and terrorisms, the role of United Nations Security Council, historical context, and the key legal terminology. Terrorism is a complex phenomenon that has plagued societies for centuries. It involves the use of violence or the threat of violence to intimidate or coerce a populations or government to achieve political, religious, or ideological goals. While the tactics and motivations of terrorist groups may vary, the underlying aim remains the same, which is to spread fear and disrupt the normal functioning of society. The absence of a universally agreed upon definitions of terrorism has hindered international efforts to combat this scourge. However, several key elements are commonly associated with such concept, such as the use or threat of violence. This is a fundamental characteristics of terrorism. The targeting of civilians, terrorists often target civilians to maximize fear and shock. The pursuit of political, religious, or ideological goals, terrorist acts are typically motivated by a desire to achieve specific objective. State terrorism refers to acts of terrorism carried out by a state or its agents against its own citizens or foreign nationals. Such acts may include extrajudicial killings, torture, disappearances, and mass arrests. While state sponsored terrorism involves a state providing support, such as funding, training, or intelligence to non state actors who carry out terrorist attacks. The International Conventions for the Suppressions of Terrorism's 1971. This convention focuses on acts of terrorism that endanger international civil aviation. International Conventions Against the Taking of Hostages, 1979. This convention criminalizes the taking of hostages and demands their release. International Conventions for the Suppression of Bombings, 1997. This convention targets acts of terrorism involving bombs and explosives. International Conventions for the Suppression of the Financing of Terrorism, 1999. This convention aims to disrupt the financial networks used by terrorists. Despite the existence of these conventions, the international community has failed to reach a consensus on a comprehensive definitions of what constitutes terrorism. This lack of universally accepted definitions has hampered efforts to combat terrorism effectively. To circumvent the difficulties in defining terrorism, the international community has adopted a sectoral, segmental, or incremental approach addressing specific types of terrorist acts through targeted conventions. To circumvent the difficulties of these providing definitions, the international community has adopted what is known as sectoral, segmental, or incremental definitions approach. Criminalizations of terrorist acts. These conventions criminalize specific acts of terrorism, such as hijacking, hostage taking, and bombings. International cooperations. The convention requires states to cooperate in investigating and prosecuting terrorist offenses. Extraditions and mutual legal assistance. The conventions establish mechanisms for the extraditions of suspected terrorists and mutual legal assistance between states. Some states have adopted laws that allow them to prosecute terrorist offenses committed outside their territory, regardless of the nationality of the perpetrator or victim. This principle, known as quasi-universal jurisdictions, is based on the idea that certain crimes are so serious that they should be prosecuted by any state with the capacity to do so. Some states have adopted laws that prosecute terrorist offenses, even if it is committed outside the territory, regardless of the nationality of the perpetrator or the victim. This is what is known as quasi-universal jurisdiction. The issue of refugees and terrorism is complex and controversial. It is important to protect refugees. It is also necessary to prevent them from being exploited by these terrorist groups. States must strike a balance between these competing interests. Terrorist acts, regardless of their political, ideological, or religious motivations, are considered ordinary crimes and can be prosecuted where they occur. However, extraditions can be challenging if the perpetrator flees abroad. States may not have jurisdictions over crimes committed outside their territory unless they exercise extraterritorial jurisdictions, which is not always feasible for common law countries. Universal jurisdiction allows any state to prosecute crimes like piracy, slavery, war crimes, and crimes against humanity. But terrorism has not yet achieved this status due to the lack of comprehensive international definitions. Terrorism, though prominently highlighted after 11 September 2001, has existed for centuries. The international community's formal response dates back to 1937 when the League of Nations drafted the Conventions on the Prevention and Punishment of Terrorism, though it never came into force due to World War II. Terrorist acts are fundamentally ordinary crimes, even when motivated by political, ideological, or religious reasons, and they can be prosecuted in the jurisdictions where they commit such act. Between 1970 and 2005, 13 major conventions were concluded to address various aspects of terrorism. These include conventions on aircraft offenses, hijacking, civil aviation safety, and more. Some of these are Universal Tokyo Conventions, 1963, aircraft offenses, Hague Conventions, 1970, aircraft hijacking, Montreal Conventions, 1971, with regards to civil aviation safety, Diplomats Conventions 1973, Hostages Conventions 1979, Nuclear Conventions 1980, Montreal Protocol 1988, Airport Violence, Rome Conventions 1988, Maritime Navigations, Plastic Explosives Conventions 1991, Bombing Conventions 1997, Financing Conventions 1999, Nuclear Terrorism Conventions 2005, and Rome Protocol 2005 with regards to fixed platforms. States must extradite or prosecute offenders. Recent conventions exclude political exceptions. Quasi-universal jurisdiction requires states to establish jurisdictions over offenses committed in their territory by their nationals or against their vessels or aircraft. The extradite or prosecute, ut dedere, ut judicare. They extradite the accused or submit the case to their own authorities for prosecutions. Quasi-universal jurisdictions creates jurisdictions between state parties. It requires parties to establish jurisdictions over offenses committed in their territory by their nationals or against their vessels or aircraft. Some of the notable cases, such as Lockerbie Case 1988, it involved Pan Am Flight 103 sabotage, led to United Nations Security Council resolutions number 731, 748, 883, and 1192, resulted in trial in Scottish court in Netherlands. One accused, Megrahi, was convicted in 2001. Zardat case and Emmanuel case are also part of the notable case involving international terrorism. In 2008, the Emmanuel case led to a United States federal court convictions for torture and hostage taking in West Africa, demonstrating the implementations of conventions, obligations in domestic law. In 2005, the United Kingdom prosecuted Zardat for hostage taking in Afghanistan. This case demonstrated the practical applications of quasi-universal jurisdiction. The United Nations Security Council has played a crucial role in combating terrorism, and they adopted numerous resolutions and imposing sanctions over terrorism activities, groups, and individuals. The Security Council has passed resolutions such to address terrorism, including post 9/11 measures and sanctions against Taliban and Al Qaeda. The sanction regime includes asset freezing and travel bans. Human rights considerations are crucial, ensuring resolutions do not violate fundamental norms and allow for a fair trial. The Security Council must respect human rights. Resolutions must respect human rights, including jus cogens, norms, and fair trial rights. They should balance security needs with human rights protections, as highlighted in Kadi case at the European Court of Justice, which challenged implementations of United Nations sanctions regarding due process rights. The sanction regime includes maintaining terrorist lists, asset freezing, travel bans, humanitarian exemptions, and review procedures, um, such as maintaining lists of designated terrorists. It contains humanitarian exemptions and also review and delisting procedures. The convention established quasi-universal jurisdictions. It requires states to either prosecute or extradite offenders found in their territory. It ensures that no safe haven exists for terrorists. The conventions also address issues such as political exceptions, fiscal offenses, and the criminal liability of corporations. The Security Council has passed some of the resolutions, such as resolutions 1368 2001, following the 9/11 attack. It recognized terrorism as a threat to international peace and security. Resolutions 1373 2001 required states to criminalize the financing of terrorism and freeze terrorist assets. And resolutions 1267 in 1999 imposed sanctions, specific sanctions on Taliban and Al Qaeda. Conventions on the Prevention and Punishment of Crimes against Internationally Protected Persons, including diplomatic agents, 1973. This convention criminalizes attacks on internationally protected persons, including diplomats, and obliges states to prosecute or extradite offenders. International conventions against the taking of hostages, 1979. It defines hostage taking as a criminal offense of universal concern and mandates states to make it punishable by appropriate penalties. Conventions on the Physical Protections of Nuclear Material, 1980. These conventions focuses on the protections of nuclear material used for peaceful purposes during international transport, requiring states to criminalize offenses related to nuclear material. The principle of ut didere ut judicare, extradite or prosecute. This is a cornerstone in the fight against terrorism. States are obligated either to extradite an alleged offender to another state willing to prosecute or to prosecute the individual themselves. This principle ensures that there are no safe havens for terrorists. However, there's a political offense exceptions, which historically been an obstacle to extraditions, allowing states to refuse extraditions if the offense is deemed political rather than criminal. However, recent conventions have sought to limit these exceptions concerning terrorist offenses, recognizing that acts of terrorism cannot be justified on political grounds. International cooperations emphasizes the importance of collaborations among states, international organizations, and law enforcement agencies to share intelligence, harmonize legal standards, and coordinate efforts. Human rights considerations addresses the debates surrounding the balance between state security measures and the protection of human rights of individuals and their fundamental freedoms. It underscores that counterterrorism efforts must comply with international human rights law. Terrorism remains a persistent threat to global security. While international efforts have made progress in combating this scourge, challenges still remain. To effectively address terrorism, it is essential to strengthen international cooperations, improve intelligence sharing, and develop comprehensive strategies that target the root causes of terrorism. And this include poverty, inequality, and political instability.